public trust and confidence in the judiciary. To look at the police side of the job. It is common knowledge that almost invariably the police arrest suspected offenders upon reports which contain allegations first and investigate later. In the media today, or the recent past, there are reports of arrests of people by the police and by the army, kidnappings, violent deaths, missing persons, and so on. There are a number of police and military vehicles full of armed personnel reported to be involved. There are also reports of drones, vehicles without number plates or with disguised number plates and manned by personnel not in uniform involved in these activities. Who is investigating what is required to be investigated? The police, the army, or both? I have seen literature and heard comments against deploying the army to keep law and order in peacetime, primarily because of different training and purposes. The police are trained to keep law and order. The army is trained to destroy the order of the invader or attacker. I would add a qualification to deployment of the army with a tag without a state of emergency. I say this because I know that the Constitution provides that the security forces shall observe the law in their operations. In a state of emergency, however, the same Constitution permits variation of certain laws which are allegedly being trodden by the security forces. One view is that the existing pandemic, which may be the cause of the current situation, is not a state of emergency, although it may lead to a declaration of a state of emergency. In respect of the performance of the judiciary, it is said that justice must not only be done, but must be seen to be done. Justice must only be done, but must be seen to be done. That seems to be a good yardstick or measure of performance, and should apply to all the three arms of the government. With your consent, I'll make one observation regarding the judiciary. In the book we are launching today, there are references to writing judgments generally, but not about judgments in appellate courts or courts with more than one judge sitting on the panel. The law provides that in such courts, all judges have equal jurisdiction. All judges have equal jurisdiction. And for that reason, the decision of the court is based on majority views. For the same reason, the quorum in such courts consists of an odd number of judges on the panel. This is to avoid a tie, as there can be no draw in litigation. Practice has been that at the end of the hearing before such a court, one member of the court is assigned to write a lead judgment, which is circulated to all members. Comments and suggestions are made, which lead to a final draft. The other members of the court write their own judgments, supporting or dissenting from the lead judgment. These are also circulated and may attract comments and suggestions. All judgments must be ready before the date fixed for delivery. Normally, the lead judgment is read first, followed by the judgments of the other members in the order of seniority. The presiding officer, unless he or she prepared the lead judgment, reads his or her judgment last and pronounces the verdict of the court. The court should be in session until all judgments have been delivered. I have also read in the media that some judges do not circulate copies of their draft judgments to other members of the panel prior to delivery of the judgments. This is most unfortunate. The raison d'etre for a collegiate court is a collegial discussion, and each member of the court ought to circulate their decisions to all other members in a timely manner. You may actually persuade your brothers and sisters to abandon their position and follow your reasoning after they have read your draft judgment. Independence of the judiciary cannot be justification for withholding a decision from the other panel members. Failing to do so may well amount to unethical conduct. What happened in the Supreme Court in the recent past was most unfortunate. Applying the same measure of performance to Parliament, it must not only make laws for the peace, order, development, and governance of Uganda, protect the Constitution, and promote democratic governance of Uganda. Parliaments must not only make laws for the peace, order, development, and governance of Uganda, protect the Constitution, and promote democratic governance of Uganda, but must be seen to do so. On one occasion, I considered one law as the worst law Parliament has ever made, and I gave my reasons. Not long ago, a learned brother saw the same law as a mistake by Parliament. Let us look at another law which provides that civilians shall be tried by a military court for certain offenses. One obvious question would be, I am not a soldier. Why should I be tried by a military court? Over 30 years ago, self-styled Field Marshal, conqueror of the British Empire, life President of the Republic of Uganda, Amin Dada, set up military tribunals to run side by side with the civil courts, and a civilian could be tried in any of the two systems at the whims of the government. In one case, a Mzungu civilian was tried in a civil court. A Mzungu civilian was tried in a civil court, was not only acquitted of the alleged offense, but was also granted costs. In criminal law, the grant of costs means that the court considered the offense frivolous and vexatious. Life President Amin said publicly that the Mzungu tried again by the military court would be convicted and sentenced to death. This is exactly what happened. What a marvelous prediction by the president. I was the Chief Justice with no jurisdiction over military courts and could do nothing to that travesty of justice where a plea of auto fa acquit was a perfect defense in one court system, but meaningless in the other system. Yes, there was a right of appeal, but not to a superior court, but to the president, and only on one ground: clemency. Lastly, in respect of the executive authority of Uganda is vested in the president, which must not only be exercised in accordance with the Constitution and the laws of Uganda. Executive authority must not only be exercised in accordance with the Constitution and the laws of Uganda, but must be seen to be so exercised. What would an onlooker or observer looking at Uganda today say? Or better still, what do the people say, all in all, I would say, let us develop our institutions, equipping each one with the necessary infrastructure and personnel, and doing everything required to enable them to perform their functions. It may be necessary to realign our priorities. This will pave the way for the judiciary to ensure and enforce independence of the judiciary demonstrated by Chief Justice Benedicto Kiwanuka. I turn to my old friend Shakespeare, who ended the 7 stages of man on the world stage thus: last scene of all that ends this strange, eventful history is second childishness and mere oblivion. Sun's teeth, sun's eyes, sun's taste, sun's everything. I thank you for listening to me so patiently.
There is always light at the end of the tunnel. Enter an era of new life and opportunities with